Here the defendant was somewhat reclusive. His behavior was getting stranger in the days and months leading up to the crimes. The court must consider the viciousness or aggravated nature of the crime. Here it was extremely vicious. It was attacking victims while they slept in their beds in a most vulnerable state. The court must also consider the degree of the defendant's culpability. Here there is very little culpability. There's some victim blaming, some medication blaming, but very little remorse is being shown. The court must also consider the age and health of the defendant. Here he's 28 years old and in relatively good health. His education is college educated. Employment history is somewhat difficulty holding down a job. The rights of the public as well as the family need to be considered here, and they certainly have been through great difficulty over the past several years. That being the family has been through what no family would ever want to endure. That is the greatest importance, is protecting the public as well as the family in this particular instance. The court weighs heavily the opinions of the family members in this case. All things being considered, Mr. Metzig, you are hereby sentenced to life in the Wisconsin State Prison System as to count 1 with no possibility of parole. It will be the same sentence as to count 2, and both sentences will be consecutive to each other. There is no eligibility for the substance abuse program or the challenge incarceration program. Because of this conviction, you may not vote, and it is unlawful for you to possess a firearm or body armor. You do have the right to seek post-conviction relief. A notice of intent will need to be filed within 20 days. You also need to pay all court costs associated with this case. As to the restitution request,
the defense have filed a restitution request to cover relief, some attorney's costs and funeral costs, so that the defense stipulates.
Is the restitution being objected to?
No challenge to the restitution.
So the restitution request in document 143 will be ordered as well. Is there pre-sentence credit amount that needs to be
deferred?
So that will be reflected on the judgment of conviction as well. Is there anything further from the state?
No, thank you.
Anything further from defense?
No, thank you.
Then we are concluded on that matter.
My parents were making me mentally ill, and I had sought out help specifically with them both immediately and sometime prior to the offense. So, for example, when I was immediately prior to the offense, I was on a trip with my parents in Israel. I had sought out emergency contact services about my parents because I was concerned about them. I literally reached out to the emergency services and said, I'm very, very concerned about my parents. There's something, I really need help with them. I tried to keep as much distance from them as possible. A year prior to the offense, I had reached out to a family friend and expressed to him how unsafe and how concerned I was about my parents for my own safety. And I asked him if I could move in with them. When I had been seeing my clinical psychologist, we had discussions, and he had pointed out to me how my parents were causing me to be depressed, causing me to be mentally ill. And that is something that, at the time that the offense occurred, I was severely mentally ill. I was mentally ill to the point of hearing voices. And I think anyone who has seen the discovery, has read related materials, has noticed my behavior, would obviously conclude that. And when you are mentally ill, it's very, what is or is not a reasonable action changes dramatically. If you can't, despite your efforts, if you can't live on your own or hold down a job or safely live on your own, then the options of what is a reasonable action for an individual, the calculus changes. And I was suffering the malign influence of prescription medication that I did not want to take. Due to the antidepressant medication I was given, I was more irritable and aggressive than I've ever been. And that was something that I was not even aware of at the time. I was not consciously aware of that. It was after I was speaking with my attorney, Stephen, he said, there's, anyway,